Let me just say very quickly before we start that there's confusion over what was decided in the PDP primary in Edo State. The PDP itself is saying now that there was no such judgment delivered, that they themselves are not aware of a judgment nullifying their primary. We're hoping that that will be clarified when the National Publicity Secretary of the PDP, Ibrahim Abdullahi, comes in the second half of this program. But it's just an important point to bear in mind. Some more legal confusion as far as the Edo State PDP primary is concerned. Now, there appears to be a big question mark tonight as well over who won today's appeal court ruling on the issue of the lawmakers in Rivers State who are loyal to the Minister of Abuja, Nyesom Wike, and whose seats have been declared vacant. Shouts of victory have been sounding in the Wike camp following the ruling, which at first glance seemed to nullify the expulsion of the Ameule-led lawmakers from the Rivers State House of Assembly by the State High Court. But lawyers who've been interpreting the ruling have said that there is nothing to celebrate and that the Martin Ameule-led lawmakers remain sacked because the court did not, in fact, rule on that substantive matter, which is yet to be determined. All it did was rule on the very specific, very narrow issue of jurisdiction. Nevertheless, the already acrimonious dispute now appears to be leading to another disagreement over today's judgment. And that's not good for Rivers State, where the political landscape remains tinder dry, ready to be consumed by sparks that fly on an almost daily basis between these two political enemies, Minister Nyesom Wike and Governor Sim Fubara. A concern for all those who watch Rivers State and fear that the escalating exchanges could erupt into something much worse. So in that regard, how should we correctly interpret today's appeals court ruling?
What point are we trying to make? That the seat of the 27 lawmakers have been declared vacant, and there's no judgment that have quashed that declaration of those seats vacant, and there's no court anywhere in Nigeria that have decided that they are cross-carpeting from PDP at the time there was no division to APC is legal. And let us be mindful of the conversation we're having in the public space. Are we not saying because of the vaulting ambition of one man that our constitutional democracy and constitutional march should be retarded? That somebody is fighting, and because of his desperation, he gets some young men in the House of Assembly to jump into another political party when there was no division, in their desperate way to force Fubara out of office unconstitutionally. And suddenly they realize the stupidity in their action. And then suddenly they are running around all courts in Nigeria, so that our court will say what? Our court will void those provisions of our constitution. Is that going to be a progress? That lawmakers can jump ship at any time they like and then remain in office, even when there's no prevailing need or reason for that. That is what we are fighting for. That is what this matter is all about. An attempt to undermine our constitutional march. And these are the things that led to crisis. If you remember, those days, both in the Western Regional House of Assembly, and so that even led to a crisis and military coup. This commotion, when people see simple truth, did they not decamp? Yes, they decamp. Did they not have a vote on proceeding back in it? Yes, there is. Did they not publicly say it? Yes, they did. Did they not file it in affidavit before Justice Omotosho and other Federal High Court judges that they left PDP as of December 2023?
Well, for his take on today's developments around Rivers State, I'm joined now on the line from Port Harcourt by the lawyer and human rights and media activist, Chief Festus Ogwuche. Thank you very much indeed for joining us. A very emotive issue, once again, as we can see. I mean, in addition to the legal model that appears to be emerging out of this, but let's just be clear that this was not the absolutely earth-shattering judgment that we've all been waiting for, which is the substantive matter of whether Martin Ameule and his fellow lawmakers or sacked lawmakers in Rivers State can retain their seats. This is about an ex parte order delivered by a lower court restraining Mr. Ameule and his colleagues from parading themselves as lawmakers. In that regard, how do you interpret today's ruling?
Yes, thank you, Charles, for inviting me. I don't think there's any model in it. We won't expect anything earth-shattering, as you said, from the judgment of the Court of Appeal. I was not expecting that because the issue, as you said, is very narrow. The High Court of Rivers State, per Justice Wali, had given an order restraining the Amehule-led House of Assembly from parading themselves as members of the House of Assembly and other sundry orders that he made. And these gentlemen were yet to be put on notice, but when they got wind of the proceedings, they went straightforward into the Court of Appeal for the interpretation of that decision regarding the jurisdiction of the court to determine that issue. And that's all the court did today, to determine whether the lower court, the High Court of Rivers State, has jurisdiction to entertain that matter in the first place, and that is where the issue is. The decision of the court does not give anybody any unilateral powers or rights to restoration or to change the status quo as it exists right from the onset. I would say that we've been having so much cherry picking with judicial pronouncements here and there. We call it forum shopping here. There's judges from the Federal High Court making decisions, and they begin to impede against themselves with other orders of courts that create a lot of conflicts and touch on judicial integrity. I think the judiciary should have been a little more circumspect and allow these issues to go the proper way, the proper direction, and not to begin to entertain several actions, several issues on the same subject matter, even though the parties are different. At the end of the day, it gives the politicians the opportunity to go foreign shopping or cherry picking between which courts to go to and which court not to go to. I think it is one single judge that did what I consider as appropriate, the Honorable Justice Ogwuche. He took a look at the case before him and took a look at the order made by the Federal High Court and said, well, I don't have jurisdiction. And that is the end of the matter. And I think we want more judicial appropriateness in that direction, that there should be a synergy amongst the courts to know which one should be entertained and which one should be discarded. But what the Court of Appeal did today is to determine whether the Honorable Justice Wali of the High Court of Rivers State has jurisdiction to entertain that matter, or whether the matter before him was competent. And they anchored their decision on the provisions of Section 272, sub 3 of the Constitution, to the effect that the Federal High Court has the jurisdiction to determine the vacancy of positions of members of the House of Assembly. Even though the court went later to say it is exclusive, I disagree with that totally. It cannot be found within the notion of exclusivity for the Federal High Court to exercise that jurisdiction, because we are talking about a House of Assembly that is within states. There could be a concurrency, but that is for the Supreme Court to determine.
Well, thank you for that, and thank you for trying to explain these things for us, because there are a lot of ordinary people who will be challenged by what is going on and pretty much confused by it, and not just ordinary people, but even the greatest intellectuals. But please bear in mind that it may sound as if I'm making you repeat yourself as a result of my questions, but our job is to try and seek absolute clarity, or to get to as close as clarity as we possibly can, so that our audience can understand what is going on. So basically, the appeals court has not changed anything or said anything contrary to the provisions of the Constitution with regard to the defection of the lawmakers. All it dealt with was the issue of the jurisdiction, and by extension, the issue of possible judicial overreach.
You said it very, very correctly, I will say, Charles. The substantive issue has yet to be determined, even at the High Court by the Honorable Justice Wali. It was even the ex parte application that prompted the making of that interim order. It was the interim order that is the subject matter of appeal. The lower court has not even gone into the substantive issues. But I would say that also the Court of Appeal could not delve into those issues because it is yet to emanate as an appeal to the Court of Appeal. The Court of Appeal only exercises appellate jurisdiction. I cannot go into determining substantive issues. It was purely an appeal on the basis of an interim order made by a court, on whether the court has the jurisdiction, the competence to determine that case. So the substantive issue is yet to be touched. But if you look at that order, you look at it and you think that maybe after that order, is there anything in the substantive action that needs to be determined by court? Because I'm very, very sure that if you look at the prayers or the reliefs in the pleadings before the lower court, it must be the same thing as what the court had ordered. And that is why we are saying that circumspection on the part of the judiciary is very, very important. And while that is going on, I also believe that the parties cannot give their own interpretation to judicial decisions. They are there. And everybody understands that, well, this decision of the Court of Appeal today has not given anybody anything. It has just defined the limits of the exercise of jurisdiction of the High Court of Rivers State with regards to the vacancy of the membership of the House of Assembly. And we are also saying that, well, the National Assembly also has the powers to determine that vacancy by virtue of the Constitution. Whether it panders with the constitutional and the federal framework or not is a different matter altogether. These are constitutional matters. It's for the courts, particularly the Supreme Court, to give an interpretation that will satisfy all and sundry and maybe help us to develop our case law and jurisprudence. But by and by, there's nothing that is gained from that decision. There's nothing that is lost. The only alternative available for the parties is that to go and initiate a fresh action at the Federal High Court or go appeal the decision in the Supreme Court, where we can have better understanding of what the Court of Appeal is saying. But to the very best of my knowledge, the people jubilating, I don't know what they are holding on to, and I don't see what is there that gives them any cause of joy or anything. What is important is that the court later went, though it is in a concurring decision of the court to say the status quo be maintained. What amounts to the status quo is what we may not rightly here state. But then, that's what I consider to be an obiter dictum of the court, because having stated that the lower court has no jurisdiction, there's no other material, there's no other subject before the court for it to make that order for maintenance of status quo.
Well, I mean, that really is the key question here. I mean, would it be fair to say that the seats of those lawmakers remains vacant? Because, I mean, you said it's not something you can answer, but it raises the question of what is the status quo?
I agree with you completely. The status quo, as we know, is one that's established by law. And we've gotten a lot of case law on that. I think the leading one is from the Honorable Justice Chukwudi in Governor of Lagos State against Ogwuche. And he defined it in very simple and straightforward terms, in his usual characteristic elegance. The status quo as it is currently does not state that the 25-member House of Assembly led by Ogwuche can go back to their seats, revert back to their positions. No, the status quo as it is that they had moved on. They have defected, they have jumped ship, and the Constitution recognizes that fact. And there's what we call judicial notice, which can be taken of that defection, though they are coming from different other directions or angles to say that, well, it doesn't apply with us. But then that's for the courts to pronounce. But once that issue happens, to the effect that a legislature has vacated his position, he has gone, particularly if it is done voluntarily. So the status quo to be maintained is that those members, 25 members, have not been restored. The 3-member structure cannot constitute themselves into a House of Assembly as far as I'm concerned. Because somebody is talking about the doctrine of necessity. It cannot apply in legislative activities. You can, because that will be tantamount to usurping the position of the electorate. It is they that put them there. You cannot apply the doctrine of necessity in elective positions. Doctrine of necessity comes into play in administrative actions of the governor. That where there's a vacuum of this nature, the governor can go ahead and do certain things within the ambit of its necessity, within the carapace of its necessity, to keep the function or the state of governance going. not to ascribe it to legislative powers or legislative actions. As far as I'm concerned, the three-member House of Assembly cannot constitute a House of Assembly for the state. The membership of the House of Assembly, by virtue of Section 96 of the Constitution, is construed from the constituencies, the number of constituencies present, not the number of lawmakers present in the House. So if you're talking about 2/3 or 1/3 of the House of Assembly, you are looking at it from the totality of the number of seats available, not necessarily the physical representation of the members who are elected for that purpose.
Right, okay.
So there's...
Finish what you're saying.
Sorry.
Finish what you're saying.
And so there's no issue of either of the factions of the House of Assembly, whether you are for the one for Amehule or Okojumbo, constituting themselves in the House of Assembly in the interim while this controversy is going on. There's not yet a House of Assembly for Rivers State.
Right. So, okay, let me take you up on that point, because that's another contentious issue and a confusing issue. I hope you can still hear me.
I hear you loud and
From
clear.
what you were saying there, everything is now as it is until the issue of the sacked lawmakers is decided ultimately by the Supreme Court, probably. But the question I want to ask you is, who is the Speaker of the House of Assembly based on today's judgment? Who are members of the House of Assembly?
Like I said this earlier on this channel, but it's not on your program anyway. The House of Assembly as it is currently constituted is in abeyance. If you're going to give some credibility to any faction of it, then you are running contrary to the provisions of law. The thing is not that anybody should wait for anybody before it is properly constituted, even though these other people are in courts. I know there are cases before the Honorable Justice Obile and the Honorable Justice Abdul Malik of the Federal High Court, both of them, one in Port Harcourt, the other in Abuja, ordering compelling INEC, ordering that the court make order compelling INEC to conduct elections on the vacant seats. That's what it should be. In England, for instance, once a member of parliament vacates his position, the next thing is a by-election. It's like that. It's automatic. So it's not to wait that the Supreme Court will give something before you. Governance cannot be run aground because some persons are in courts or some persons are contesting their positions, particularly in the situation where the members, the 25 members, left voluntarily. And all along they have said, and it's been represented all over the place, that they have defected. They are no longer members of the PDP. If they make a detour now and say we are members of the PDP, that becomes an afterthought. As far as I'm concerned, what they ordinarily ought to have been in the real course of issues is for elections to be conducted into those positions. And those who think that they did not leave or did not vacate the office and they are still members of the office, when the election is over, they can go and contest it in the tribunals and say that those positions are not vacant. Rather than just waiting and folding our hands and expecting that the court will give decisions, and it's the decisions of the court that will make the system to function. That's not how it is.
Right.
Thank you.
I know you're dealing with the very specific legal issues, so let's kind of stay with that mostly, although at some point I will probably ask you something that's a little leaning towards the political. But, I mean, the way that you put it, it seems fairly clear. And I wonder why there's so much confusion over what the court has actually decided today. Because, I mean, as I said, it's being interpreted by different people to mean, on the one hand, I mean, if you look at all the headlines of the newspapers, they were essentially saying that those lawmakers have been reinstated by today's appeals court ruling. What is the element of law that appears to be confusing there?
Well, the element of law that's confusing is the interpretation given to it by people who are interested in the subject matter of adjudication. Each party will want to garner public opinion on its side, and they do it with so much misconception of what the issues really are. I know very well that if the subject of adjudication is an interim ruling of a court, of a lower court, which has been brought before the appellate court for determination on the issue of jurisdiction, I am convinced that the courts cannot go into the substantive issue of whether some persons have gotten that are proper to return to their seats or are entitled to return to their seats when it is the substantive matter which has not been touched at the lower courts. The appeal court's the ambit of its adjudication in this sense is very narrow to the effect that all the appellants are asking is, does the lower courts have the jurisdiction, have the competence to make a pronouncement or anything referring to the House of Assembly, regarding the House of Assembly and restraining members of the House of Assembly from doing this and doing that? And the Court of Appeal had answered no. What power has it given anybody to restore? What restoration has it done to anybody? It has done nothing. It has just determined the issue of jurisdiction as a pointer to the contestants to determine, to go to the appropriate courts for this decision. They can go to the Supreme Court and challenge the decision of the Court of Appeal, which they made today. Because there are certain issues surrounding constitutional questions surrounding that decision that need some clarification from the Supreme Court, because we are talking about the House of Assembly of a state. And we were thinking that both the State High Court and the Federal High Court has concurrent jurisdiction on the subject matter. No, it is not for me to state it right away, but it is for me to tell you that to the extent that I understand, this decision today has not given anybody any right or any power to restore himself or to put himself as Speaker of the House of Assembly, or that anybody has been declared as Speaker of the House of Assembly. The Court of Appeal couldn't have had the jurisdiction itself to make such determination.
Right. Again, I appreciate very much your explanations there, and the fact that you're interpreting it as close as you can to the audience in fairly layman's terms so that everybody can understand it. But you did mention at some point that there are those who potentially will interpret this for their own political interests. If that is the case, are we potentially looking at a showdown between the lawmakers and Governor Fubara if the lawmakers insist on interpreting today's ruling to mean that they have been reinstated?
I'm very sure that those of them who are making that point quite understand the implications of what they are saying. Somebody else has said that the implication of the ruling is also that the elongation of tenure of the local government councils is also restored, which I think is neither here nor there. You know, judicial process is not construed in that manner, and people should understand it very, very well. When there's need for interpretation, they can even return to the courts and maybe go to the Court of Appeal for a proper shedding of light on those areas that they find confusing, of which causes this kind of misconception. But you see, in this political tussle here in Rivers State, there's so much to do with sentiment, so much to do with populism, appeal to populism, so much to do with certain political fireworks or grandstanding that each of the factions want to present and project that the justice is on our side or the scales are on our side. They don't even mind about, the inclination of the generality of the population. It doesn't matter to them. What interests them is that, well, they are still in the political saddle, they are still there in the forefront and what have you. And that's very, very bad for our politics, because I don't see any ambiguity in the straightforward adjudication that the Court of Appeal did today on the issue of jurisdiction of the High Court of Rivers State on the vacancy of members of the House of Assembly. There's no ambiguity whatsoever. It's something that ought to have been given a very straightforward understanding, and people will go about their business and wait for the gladiators to either go to the Court of Appeal or file a fresh process at the Federal High Court so that these issues can be taken care of appropriately.
I want to thank you very much indeed, Chief Festus Ogwuche, first of all, for your absolute clarity when it comes to issues of the law, but also secondly for being as objective as you have been, because you've been absolutely down the middle and you stuck with the letter of the law, which is what we were hoping that you would do, and you have not disappointed. Thank you very much indeed. Chief Festus Ogwuche is a lawyer and human rights and media activist, and he was speaking to me on the line there from Port Harcourt.